Welcome to the Family Law Channel. A judge has ordered San Francisco's newest sheriff to stay away from his wife and toddler son after allegations of violence. Despite his wife's tearful pleas not to keep the family apart, Sheriff Ross Mikurimi has been charged with domestic violence towards his wife, Eliana Lopez, child endangerment, and dissuading a witness after a New Year's Eve incident at their home. This is a story we've covered here on the Family Law Channel, but this newest protection order is something worth discussing. My guest is the host of the Family Law Channel, retired Superior Court Judge California, Eugene Hyman. Welcome back, Judge.
Thank you.
So talk about how one gets a protection order in this case where the wife or the victim doesn't want that to happen.
Well, traditionally in most California courts, when the defendant is arraigned, as the sheriff was in this particular case, the judge automatically issues a protection order. A protection order is issued in a criminal case. A restraining order is issued in a civil case, and that requires that the victim actually has to make the application. The protection order can be issued at the judge's own discretion, at the request of the district attorney, or at the request of the victim. In this particular case, the district attorney did request that the restraining order issue. It should be noted that initially there was an emergency protection order issued by a judge, and that in California is initiated by a police officer making contact with a judge, giving the facts of the case, which requires that there has to be the relationship test. That means there has to be a certain kind of relationship between the parties, usually a dating relationship or marriage or have a child together, and either violence or threats of violence. And the judge in the case, when the arrest was made, issued an emergency protection order. And then the criminal judge in the case, when the sheriff was arraigned, then issued a protection order, which will remain in effect unless it's modified until completion of the criminal case. If he's convicted, it could be through the period of probation. Depending upon the charge, it could be as long as 10 years. Or if, let's say, he's found not guilty or the case is dismissed, then the protection order would dissolve by operation of law because the court would lose jurisdiction. But the judge in this particular case issued the protection order at the request of the district attorney, and furthermore made it a stay-away or a kick-out order. That is, that he can't live in the house. He has to stay, in this case, 1,000 feet away. Can't have any contact by any means, nor can he have contact through a third party other than by his attorney without permission of the court.
Is outside of the protection of the victim and the family, is the dissuading charge, does that have any play here in order to prevent that from happening more, or is that a consideration? Okay.
Absolutely. In this particular case, the judge indicated that she considered the arrest warrant affidavit in terms of the facts that were contained therein, and because the arrest warrant affidavit was by the investigating inspector under penalty of perjury, she accepted that as true for purposes of the issuance of the protection order. And you're correct. The fact that there was a dissuading charge and the fact that the dissuading was basically indicated by the victim to the neighbor in terms of that he threatened to take the child away, he threatened to no one would believe her because he's powerful, the sheriff, etc., that by separating or requiring that they remain separate, it's less likely that the dissuading is going to continue.
Now, this is supposed to happen again for the entire duration of the case. I believe they're going to appeal the order. Does the fact that the wife is pleading for them not to keep the family apart, which I'm sure in a lot of cases with domestic violence is not that uncommon, does that have any bearing on the judge's decision on a plea?
Oh, absolutely. But the thing that's also interesting is the importance of local or legal culture in terms of how these kinds of things are handled. In Santa Clara County, where I presided, we deferred a lot to the wishes of the victim. Our advocates in that county requested that the theory being that the victim knows her batterer, and if she felt that it were safe, that would be something that the judge should consider. The legal culture appears to be in San Francisco that that is a consideration, but it's not an overwhelming consideration, and which I think is the better way to go. Rather than deferring to the wishes of the victim, I think that the judge should do what is believed to be overall safety planning considerations. And the judge rightfully, I think, in this particular case, given the totality of the circumstances as presented to her, and this is also a judge who, when was a practicing attorney, was a prosecuting attorney who did domestic violence cases. So she really understands the dynamics of domestic violence in terms of how things work and why sometimes women request that it be a peaceful contact order rather than a stay-away order. And she considered the totality of the circumstances and decided that safety required that it be that the protection order remain a stay-away order.
Okay, and finally, just there hasn't been any previous history of this happening in that household before, right?
Well, it was indicated, no, actually in the arrest warrant affidavit, it alleges that she told the neighbor that this happened twice in 2011, which is another consideration. Now, looking at it from the consideration of the defense, it's really critical from a defense standpoint that it be a peaceful contact order, because he needs to be able to walk into court with his wife, which has the subliminal impression that things are safe. Having this thing in place in terms of the court of public opinion is definitely not good, because again, a judge is indicating by the issuance of this order that the judge is concerned regarding his dangerousness, and that is something that he needs to change.
All right, very good. We appreciate you taking the time to update us on this case, which is now getting wider and wider attention. Judge Eugene Hyman, thank you.
Thank you.
You are watching the Family Law Channel here on the Legal Broadcast Network.